Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm hello to everyone in between. My name is Dan Balkaran, as you can see on the chyron below, and I am an associate at Samfiru Tumarkin, LLP, which is Canada's leading employee-side employment firm. So I'm going to be your employment lawyer for the next 30 minutes or so. So hit me with all your questions about all things employment and employment law, and I'll get through them if I am able to. Before we get started, I thought I would address a topic that's been in the news a lot lately, which has got an interesting name called quiet quitting. People have asked me about this, and so there it is. What is quiet quitting? What does it mean for your employment? So first of all, quiet quitting isn't quitting at all. It's employees who are in effect not going beyond the four corners of whatever their job duties are or their job description is. And so the idea here is to only do, I mean, it's been painted as sort of employees taking back their work-life balance, as it were. So no extra work, no staying late, no working from home, just doing what or being on call all the time, just doing exactly what you're supposed to do for your job and no more. And really what this is a reflection of is the historically tight labor market that we're seeing right now. The pandemic seems to have, at least from my interpretation, caused the biggest chunk of the working population, the baby boomers, to retire in significant numbers, and then lower down the population pyramid, we haven't seen that same uptake of backfilling into the labor market. And so these two giant macro forces have caused a historically tight labor market. And so employees now know that, if they don't like their job, there's another 10 more behind them. This is particularly true for unskilled labor and non-university educated labor, so non-white collar, blue collar employment. There seem to just be jobs everywhere. And so employees are taking advantage of this newfound supply and demand power that they have, and they are doing less, we'll say. And so what this really amounts to is sort of a challenge by labor to, capital, to the business owners, saying to them, hey, I'm just going to do the minimum. What are you going to do about it? Well, I mean, and they're also posting about it on social media, which is a very strange thing to someone who grew up in my area of employment. But it's a reflection of where we are in the labor markets today. Will it last? It depends how long we have a historically tight labor market for, and that'll depend on those large macro forces in terms of labor market participation. If some of the younger generations participate more in the labor market, which I assume will happen over time, then we'll probably see those jobs, the availability of jobs, sort of balance out again, and quiet quitting will quietly fade away. But in terms of your employment rights, well, I mean, if you're not going above and beyond at your work, don't expect to advance at your work. You're going to be, I mean, it's not always a one-to-one relationship, but generally the eager employees who do more, who prove to their businesses that they're invaluable to the bottom line of that business, tend to get more responsibility, more raises, and more promotions. If you're just doing the minimum, you can't be fired. Well, let me rephrase that. Your employer can terminate your employment at any time for any reason, barring a human rights protected ground or otherwise anything illegal. And your only legal right from that termination is severance. So if your employer says, well, this guy's just doing the minimum, let's get him out of here and let's get someone else in here who's more interested in working hard, then they'd have to pay you severance for doing so. And the amount of your severance is going to flow from what your employment contract says, and then your age and length of service, or potentially your age and length of service and the job that you hold. They can't terminate you if you're doing your job. They're not going to be able to terminate you without severance. That's basically the core of it. They can't terminate you for just cause. But one, don't expect to have a vertical career at your employer. well, we'll just leave it at that. Don't expect to have a vertical career at your employer, and you could be terminated, but you would be owed severance in the event of your termination, most likely. Okay, so that's quiet quitting, at least my interpretation of it. I expect it to be, I'm not going to say transient. I think it'll be around for a little while, but not a permanent feature. But that's just my own prediction. Okay, let's get to some questions. From Anne, I'm on maternity leave, but was not able to complete my probation period before going on leave. If my employer lets me go, when do I have any severance entitlements? So that's a really interesting question. I think so. Your employer is not permitted to discriminate against you on the basis of your sex, and so termination for pregnancy or because you're on maternity leave would qualify. And so your employer would be it would be very unwise to terminate you, either shortly after you return or while you're on maternity leave. You'll certainly have a human rights complaint, and most likely a severance. Depending on what your employment contract says, you could have a common law severance claim. You're still an employee, you're just on leave. So yeah, if you're outside of the 3-month probationary period, I would say yes, you're entitled to ESA notice if you fall under the Employment Standards Act. That's actually a question I've never encountered before. My instinct out there is yes, you'd be entitled to at least the statutory minimums and potentially more. But any severance you get is going to be small because you were there for such a short amount of time. Likely 1 week of severance, maybe 2 if it's statutory under the statutory minimums. If you're entitled to common law, a maximum of, in BC, there's a common law severance floor for short service employees of 2 to 3 months, escalates for a prolonged period of unemployment, and we'll say bad behavior on the part of the employer terminating you on while you're on maternity leave might qualify, although jurisdictionally that falls under the human rights code. But I doubt that I shouldn't say that. I've seen employers do it, but your employer would be unwise to terminate you while you're on maternity leave or shortly after. If you do get terminated while you're on maternity leave, you should speak to an employment lawyer right away. You can reach us if you're so inclined at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Do unions use a lawyer to get me the same legal severance entitlement that a non-union employee would get? How would an employee know if they're getting a reasonable settlement? Okay, so your rights, if you're a member of a union, your rights are governed they flow from your collective bargaining agreement, which is like an individual employment. It would be like your employment contract, but it governs all of you. And then that is subject to certain statutes. I can't remember what they're called. I don't know if it's still the Labor Relations Act or if it's something else. But so that's sort of the interplay. But you need to talk to your union rep about that, because I can't interpret what would be a good result for you flowing from the four corners of your collective bargaining agreement. So there are lawyers that certainly do work in that area that you can contact. Most of them work on the other side, the employer side. But certainly your first stop is your union representative. Second stop, a labor lawyer who does work in that area, which you can certainly find if you Google it. Okay. Melinda asks, I recently started working as, well, I don't know if I want to say all this because this is it's a unique situation, and it kind of reveals who you are, particularly because your name is unique as well. Okay, yeah, I can address the last part. So this individual is working in here, I believe, working somewhere in Canada, but she's classified as an at-will employee, and the employer is American. Okay, so Canada has some of the strongest. You might have heard on some of our shows us talk about how Canada has some of the strongest employee rights regime in the world, and that's certainly true. The United States doesn't have that. They don't have nearly the same level of protection for their employees, and so they have something called at-will employees. In Canada, you have what's called a presumption of reasonable notice. If you are terminated from your job, you're entitled to common law severance, which can be a lot. It can be as much as 24 months. You can choose at the time of employment contract formation to contract out into something smaller, but it has to be above the minimums, the statutory minimums, which would, if you're an 8-year employee, would be 8 weeks. So it's roughly 1 week per year of service. So you can contract out into the minimums. But you still have that severance floor of 1 week per year of service to a maximum of 8 weeks. The United States has something called at-will employees, where they get nothing. They get nothing upon without cause termination. And so, if you are, Melinda, if you are working physically in Canada, okay, so Employment Standards Act regime. I mean, I assume you're provincially regulated. There are some employers that are federally regulated, but it doesn't sound like it based on what you're saying your industry is. You're as soon as you're working within a province and you're provincially regulated, that province's Employment Standards Act applies to you. Okay, and so you can't be an at-will employee because that falls below the statutory minimums that you'd be entitled to upon your without cause termination, and therefore you'd be entitled to the common law. I've dealt with quite a few cases like this. If you're working in the United States, you don't have those protections, and you effectively get nothing in the event that you're terminated. So it just depends where you're working. But if your employment contract, I mean, you haven't said that you have an employment contract. You just said that you've been told that your job is at will. If you don't have an employment contract, fantastic. You get the common law upon termination. If you have an employment contract and your termination clause says that they can terminate you at will and pay you nothing, fantastic. You get the common law in the event of your termination. So, I mean, that's far off. That's in the event that you are terminated. And you haven't asked specifically about termination. You just want to know what at will means. Okay, at will means that that company that you work for purports to be able to terminate you and pay you zero. Okay, but that's just if you are working in Canada, that is incorrect and is illegal, and you would be entitled to, because of that, common law severance, which can be as much as 24 months, depending upon your length of service. So, Melinda, my advice to you is, if you're content at your job, continue to work at your job, and in the event that you're terminated, speak to an employment lawyer, contact us. You can always do so again at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. All these unique names today, which I'm hesitant to talk about. So I'll just say A. This person's name is A. My company just got sold, and I've been told I will be an employee with a new company. I haven't signed anything yet. Do my years of service carry over to the new company position? I've worked there for 10 years. Okay, this is a loaded, complicated question. So you work for company A and it's being bought by company B, okay? If company B has purchased company A by acquiring its shares, it acquires the assets. In doing so, it acquires the assets and liabilities of company A, okay? You, as an employee, are a liability because you represent money leaving the company every 2 weeks, okay? And so in the event that it's a share purchase, nothing changes. Yeah, you're just still an employee of that particular company, and you go on as normal. If they force you to sign a new contract, if they ask you to sign a new employment, this is important. If they ask you to sign a new employment contract and it's a share purchase, you don't have to, but in the event that you don't, they might fire you, and you'd be subject to the severance regime in place, that you fall under right now. So that depends on what your employment contract says primarily, and then your age, your length of service, and the position you hold. If it's an asset purchase, okay, your employment is automatically terminated by the acquisition of the assets. Okay, so for example, the company has a fleet of trucks and you work as a driver in one of those trucks, and then company B comes along and buys those trucks, and you no longer have a job at company A because you drove those trucks, but company B says, come work for us. Your employment is effectively stopped with company A, and any severance that you claim you have would be against company A, but it would be eliminated if company B just continues your wage as was before, but now you're effectively you were a 10-year employee, but now you're a 0-year employee, and it starts again, and you're working under the new regime. And if it is an asset purchase, you don't have to. They can just make you sign an employment contract, and if you refuse, you get nothing. Okay, so it's quite a bit different. There are all kinds of complicated nuances in the question of what you're talking about, and I can't go over them here. If a lot of times in your situation, when it's a share purchase, they'll say in your new employment contract or some other documentation that your 10 years of service continue, which is what you want. Okay. If there's law in BC which says, it's a Court of Appeal case, that if they say nothing, then your 10 years of service continue. Okay? But if they tell you that they don't continue, I'd have to look at that further. I think you might have to claim constructive dismissal at that point if you wanted those honored, but then you'd be gone from the company at that moment. It's probably not what you want. So there's so much nuance in what we're talking about here that it might be a good idea for you to talk to an employment lawyer just to make sure you understand what your legal position is. Again, you can reach us at employmentlawyer.ca, helpemploymentlawyer.ca, and 1-855-821-5900. There's a lot going on here, and it could be, depending on what you do, that you have an election to make with respect to moving on from the company but getting severance versus staying with the company and losing your 10 years potentially of severance. Or it might not, depending on what the new contract says. Like, there's a whole bunch of permutations and variables. And so if I were in your position, I would talk to an employment lawyer. I would get a little, an hour's worth of advice to find out exactly what this change means to me, because then you'll know, and then you can govern your affairs accordingly. And it's actually a good time. I usually talk about this at least once a show. You should, if something of consequence is happening to you, particularly if you have, like A here, if you have a decade in the tank in terms of years of service, and your employer changes something or something significant changes, it's almost always better to talk to a lawyer first, okay, before you make any decisions, because there are things that as an employment lawyer I just can't fix. So if you talk to me ahead of time before you take action, I can potentially guide your actions, or at least give you advice that allows you to make the best choice for you, that can engender the best results, we'll say. But there are times where, given what the nuance of the law is, if you just do something, you might be married to whatever it is you did, and I might not be able to resolve it for you, or you might leave value on the table, or it might have eliminated value for you down the line. So, talk to an employment lawyer. In most cases, it's better to be proactive than try to clean something up after the fact. Okay, where are we here? Same question. We'll move on. Nick asks, my employer laid me off without benefits at the start of the summer due to lack of availability of work. They sent me a letter recently offering to reinstate my health benefits. If I sign and accept a longer layoff period, should I sign this? No, you shouldn't. What does it mean for my job if I do? I'm a diabetic and have a lot of medical expenses. Oh, okay, well, maybe you should. All right, so here's the deal. Your employer, if your employer is provincially regulated, it has your temporary layoff due to a lack of work, we'll say, can last for a maximum statutorily prescribed period. So in British Columbia, it's 13 straight weeks, or 13 weeks out of any 20-week period. I don't know what it is in Ontario. I imagine it's about the same. Ontario has this status called infectious disease emergency leave, that if your layoff was due to COVID-19, you basically sit in this status for it's been 2.5 years or whatever it is, and it doesn't get your termination doesn't get triggered. And the reason why it's important to get to termination is because that triggers your severance rights, right? So you can't, if you're not terminated, you don't get severance, right? So your only legal right in the event of your termination is severance. But if so, your layoff is statutorily, bracketed. It's got an end date. But if you agree to the benefits, have you agreed to modify your job in such a way that they can leave you on sort of a permanent leave, but you get benefits? I think possibly, yeah. And I think then at that point, you'd be precluded from claiming constructive dismissal and then not get to termination, which means you would never get severance. You'd just be on benefits, in perpetuity. I appreciate the diabetic thing is serious. Your medical expenses are, and your insulin and all that stuff is an expensive real cost for you. So I would, sound like a broken record today, I would talk to an employment lawyer. In your situation, you need to find out what is the layoff regime where you are, because I don't know what the province is. When does it end? Like and how long have you been there? What does your employment contract say? Like if you've been there for 20 years and or 25 years and you have a best day severance and you have no employment contract and you have there you go. I'm gonna get to that in a second. And you have no employment contract and you have a best day severance of 24 months, you need to get to termination, right? Benefits are paltry compared to that value. But if you've been there for a year and you've got a best day common law of 3-4 months, or you've got an employment contract that's ironclad and limits you the statutory minimums, then certainly you may want to accept that. But just all control over your employment destiny is removed from you potentially if you do sign that, because you're basically just in this limbo status while getting benefits for however long they want to keep you there. So, and if you're getting EI, that might work, but what happens when that EI runs out? So I would talk to an employment lawyer. You saw the card on the screen. I'm going to give you the information again. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. JR asks, what determines whether or not an unemployment insurance claimant can have access to any information, or if none, about an investigation? It's over a month now that I've been waiting. I don't know what you mean. I don't know what this question pertains to. Who are you trying to get this information from? Are you trying to get it from your employer? Are you trying to get it from EI, from Service Canada? Service. Okay, so I'll address part of this. Service Canada. So you pay into EI benefits your whole life, and it's supposed to be an emergency lifeline in the event that you lose your job. Okay, and then during the pandemic, the federal government said, "Well, if you didn't get vaccinated, you don't get this emergency lifeline that you paid in your whole life to get." And if you have a mortgage to service or kids to feed, too bad. You should have just gotten vaccinated. So whether your entitlement to EI was curtailed significantly at the policy level, although not the legislative level, by that policy change from the federal government. And so if your employer says that you got terminated or suspended due to failure to vaccinate, Service Canada will investigate. Investigation might take a while, and then they'll deny your claim. However, in the event that it wasn't a vaccine termination, but there's something that causes the employer to investigate, like it was a dismissal, well, then it causes EI to investigate. Service Canada will then call your employer, find out if it was a just cause termination, and then potentially deny your EI, and then you have to talk to them and say, no, I'm disputing just cause, and so forth. So you can call Service Canada and it can be on hold for a few hours, but call Service Canada and say, hey, what's going on? And they should provide you with information. But this is a question that I can't really answer. If I'm right about what you're talking about, you need to call Service Canada and figure it out with them. But that's where, if there's an investigation, they are trying to determine, Service Canada is trying to determine if you are in fact entitled to EI. So that's what's going on there. excuse me. What does an employer mean? What does it mean if an employer is trying to classify you as being an AWOL employee? I work in the entertainment industry, so scheduling fluctuates. Yeah, so AWOL stands for absent without leave. It's not a term of art within Canadian employment law. I think what they're trying to say is that you abandon your position. So if your employer said, "Hey, work on X," like you're working in the entertainment industry, so you're it's not steady employment, it's sporadic. When you get called, you got to go, and then you might work 36 straight days, and then you're done, and then you might be off for 2 weeks, and it's intermittent, we'll say. So if you keep rejecting calls to come to work, they might say you've abandoned your position, but I don't know what you do within the industry. Generally, my understanding of the industry is that in a lot of sectors, you're a member of that industry's union, and then they call you, and if you don't go, it's just the next guy up gets it, right? But if that's not the case, basically, if what I described is not how your employment is structured, if your employer is saying you're absent without leave, they're probably saying you quit. That's my interpretation. So you need to get clarification on that. Just so you know, resignation is very hard to perfect. Employers try all the time to say, "Oh, Bob quit, therefore we owe him no severance." There's an obligation, particularly in British Columbia, for employers to demonstrate that they knew the employee quit, and they took steps to confirm it, and took steps to ensure that if the employee was emotional at the time he quit, that they gave the employee time to cool down and then confirm that he actually really did want to quit. So, I mean, that's a lot of background stuff. I will say, I don't know what your name is, but again, sound like a broken record. You need to talk to an employment lawyer. You need to, if you want to get a hold of us, employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. So let's see. JR follows up. Oh, no, it's the same email, just sort of or same post just got cut off. It's been over a month now that I've been waiting to receive benefits in the form of an unemployment check. Yeah, JR, you got to call Service Canada. You got to wait on hold for 2 hours or so, talk to them and just say, "Hey, where's my money? What's the problem?" Find out. But unfortunately, the first line of defense at EI is it's all policy driven. So that's not something that I could help you with. For example, an employment lawyer could help you with. You could appeal any negative decision, but that would take a long period of time. What you really need to do is if they're not paying you, figure out why, and see if you can convince them to pay you, because you did pay into it your whole life. In some circumstances, you won't be able to, but an amicable solution with Service Canada is what you want here. Hazel said, "Tough questions today." Thanks, Hazel. I appreciate you. I agree. These are really good questions. Nancy asks, "My job is a superintendent of apartment building, and it was sold to a new owner. Your boss was just let go. His property manager. There's a new company taking over. I have not got new contract, I guess, for the company yet. Just wondering, would my years keep going, and have done this for 15 years? Yeah, I already answered this question earlier. I don't know if you saw it, Nancy. It depends if it's a share purchase or an asset purchase. So you need to find out. So number one, you need to find out if this was a share purchase or an asset purchase. If it's a share purchase, you need to, if they give you a new employment contract, it might set out whether your years of service are continued. If it's an asset purchase, they're not. But if they hire you on, then great, you get to continue your job there. If it's a share purchase and they don't say anything, your years of service in British Columbia anyway are continued. I don't know about the other provinces. There's a lot of nuance here. Just like the other person who asked this question, you need to talk to an employment lawyer. You can call us at, you can give us a call, you can contact us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Hazel, thanks for my help. You're most welcome, Hazel. Everyone's so nice here. The individual who asked about the absent without leave thanked me for my time and expertise. Then he gave me a little crown emoji, so that's nice. I tend to go long here, but we're out of questions. I guess I'll do one thing. Thank you all for your questions. They were great. the other thing that's happening a lot in the news is there's been a lot of tech sector layoffs. Some sectors are more susceptible to the ebbs and flows of the economy than others. And so, we're in a historically tight labor market and the economy is still functioning, but the stock market has turned down. And, as inflation continues to be a problem and central banks the world over start to tighten interest rates in order to, they're dealing with mass layoffs, starting to tighten interest rates, what employers are banking on is that the economy is going to start to dive down a little bit. And so because certain industries like tech are very much cyclical and attached to the economy, these seem to be sort of preemptive layoffs, particularly, given that we're not all at home anymore all the time like we were during COVID. And so our purchasing patterns have changed. And so, layoff is a misleading term. Most of these are terminations. Okay, so layoff is, in employment law, layoff is your job is effectively placed in a holding pattern status for a defined period of time that is prescribed by a law. Okay, and then you either come back or you don't. And if you don't, it becomes a termination and you get severance. The way these tech companies are using it is the other sort of colloquial term for layoff, which is you're fired, right? So without cause termination, it's not because of anything that you did specifically. It's because the employer decided to shed 40% of its workforce for its own business reasons, and then so you're entitled to severance for that termination. And in almost all cases in the tech sector, they're providing you with some form of severance package on the way out the door. What you need to determine is whether or not remember, your only legal right in the event of your termination is severance. Okay, so what you need to do is you need to determine whether or not that severance package you're being offered is, I don't want to say fair, whether it's congruent with what your legal rights are. Okay, and so you as a layperson is not going to be able to figure that out, and so you need to talk to an employment lawyer. I know I sound like a broken record today, but if you have been laid off, terminated as a result of these tech sector mass layoffs, you should talk to an employment lawyer right away. You can reach us if you want at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900, and we can assess whether or not the amount of severance that you were offered is a fair amount and in line with what your legal rights are, and then advise you from there if it's not. Okay, listen, great questions today. Great participation. Really appreciate them. I wish everybody a safe and wonderful weekend. Coming up, I believe we'll probably see it on the Chiron coming up here in a second. I believe the wonderful Mr. Darren Saul is doing the next round of Facebook Live coming up on September 6th, I believe. So don't miss that. I will be back in 2 weeks. I look forward to, there it is. Darren Saul, September 6th, 1:30 Pacific time. Join him for that. And otherwise, I will see you in 2 weeks. I look forward to your future questions. Thank you, Hazel. Appreciate it. And have a wonderful weekend, everybody.